This morning on Hard Talk is actually the only time that you hear and see judges talk outside of the courtroom. Now, Article 125, Clauses 1 and 2 states, and I quote, "The justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to the Constitution, the 1992 Constitution. And citizens may exercise popular participation in the administration of justice through the institutions of public and customary tribunals and the jury and assessor systems. Jury trials are part of our criminal justice system in Ghana." Yesterday, I asked about jury trial in Ghana, and I got very interesting responses. And I will be sharing those responses on the screen so that my ladies can answer to it. But this morning, I am extremely honored to have with me in the studio Her Ladyship Justice Afia Serwaa Botwe, a Justice of the Court of Appeal. My lady, you're welcome.
Thank you very
much. And
much.
Her Ladyship Justice Lydia Marfo, who is also a Justice of the Court of Appeal. My lady, you're welcome. It's such an honor to host both of you in my studio this morning. My lady, so I'll start with you. Yesterday, I put up a question on social media about whether people know about the jury system in Ghana. And I got very, very interesting responses. Some don't know. Some asked that, why should we do the job of judges for them? And some are saying, why should we be trying people because I'm a sinner? Why am I even telling someone or getting to decide whether someone is guilty or not? So I got the understanding that people are very not well informed, maybe some confused about what the jury system is about in Ghana. So if you can, give us some background to it so that it lays the foundation for what we're going to talk about.
Oh, great. First of all, your background is the background that we have, the Constitution. Article 125 requires that people, that is the people of Ghana, who are not judges, who are not lawyers, participate in the administration of justice either by being jurors or being assessors. And I'm sure that's easy for you to understand that there's a slight difference between being jurors and being assessors. And then we have our traditional tribunals. Then also, still under the Constitution, Article 19.2 requires that anybody who has been charged with an offense either which is liable for the sentence to be life or death sentences, to be tried by a judge and jury. Also, where the class of offense is indicated to be a first-degree felony, that person ought to be tried by a judge and jury. It is the law. It is not at all because we are remiss in our responsibilities. We love being judges, but there are instances where we need the look of a lay person to assess whether in the mind of the ordinary lay person, such a person ought to suffer the punishment that the person has been is being dealt.
My lady, so who is a juror?
So a juror is one of the 7 people carefully selected by a certain qualification under the law, who are ordinary people of the community where the victim and the community, victim and the accused person live, and who has certain values, and whose values the law expects to bear on the case that has been brought before the court.
Okay, when you say one of 7 and carefully selected,
and
what does it mean?
Under our law, if you look at the qualification of jurors, it says that subject to section 207 and 208, a person between the ages of 25 and 60 years who is resident in the Republic and who can understand English language is liable to serve as a juror. So first of all, to qualify to serve as a juror, you have to be above the age of 25 and above, and then under the age of 60, and who is supposed to be resident in the country, and also that you understand English language. And when we go to 208, then it gives felonious convicts, people who have been convicted for dishonest reasons, such as defrauding by false pretenses, stealing, and other offense such as, then you are disqualified to serve. Then you come to the 207, which gives the general exemptions of Act 30.
Okay.
Yes, Act 30 is a law that regulates how criminal trial proceedings takes place in our country. And there are a number of people who are exempt under the law from serving as jurors. So in the end, almost everybody, the president, the vice president, the speaker, and members of parliament are exempt. The judges of the Superior Court of Judicature, judges and magistrates of lower court, coroners and deputy coroners, legal practitioners in actual practice, and other court officers, registered medical practitioners and registered dentists in actual practice, registered pharmacists in actual practice, prison officers and warders, police officers, officers and other members of the armed forces on full pay, public officers other than those engaged in clerical duties, employed in the medical, post and telecommunications, customs, excise and preventive service, or under the Ghana Ports and Harbours Authority. Persons actually officiating as priests or ministers of their respective religions, that is, pastors and imams, schoolmasters actually engaged in teaching in schools, persons employed in public electric telegraph office or electric power stations, diplomats and consular representatives, and salaried functionaries of foreign governments, editors of daily newspapers, and any other person exempted by the Chief Justice. So apart from this express provision of exemptions, the Chief Justice also has the power to exempt particular class of persons.
Okay, my lady Afia, that's a very tall list of persons who are exempted. That's almost like you are not going to find anybody because everyone is in one profession or doing one thing or the other. How then do you carefully select these people to become jurors?
I think that has been our problem for a long time, not paying particular attention to the law. Because in the beginning, it actually excluded a lot of people. But now, with the kind of society we have a very large literate population. Things have improved a lot since 1960. So now we find, if we pay closer attention to the law, that there are a lot more people that we can actually co-opt to do jury duty, like you. Because if you look at it closely, we did not have to maintain just a list of people who were clerical staff in the ministries. That wasn't the law, and it has never been. We just ought to find people other than these people. Now, we have all manner of people then who can fall within, that is, between the ages of 25 and 60, can understand the English language and are not convicted felons or are not involved in any dishonesty. So with that, we have a lot more people. But at first, we were under the misapprehension that we needed to maintain a small number. And that is how come we could have 30 jurors for an entire long list of cases involving 3, 4, 5 courts. And we were becoming inefficient. But with the new, we took our time, assessed the law as it was, and we thought that we could do better. So anybody now is liable to be called for jury duty, so long as they are not exempted in these 12 or so classes. So anybody else, the managing director of a private entity, HR, anybody, all the way down to the cleaner,
right,
who can understand the language, falls within the ages of 25 and 60, and has not got any convictions.
Right. My lady, I listened to you on a different platform with Samson, where you said that the essence of the jury trial is to get persons within the community. But you also talk about English language as the person being able to understand. I know, for instance, that there are high courts in the many regions. So if there's a case that for which the punishment is life imprisonment or death happens in the northern region, for instance, do you still need someone, or do you still need jurors who understand English language when probably the person who committed the crime cannot speak English?
Yes, we still do. We still do, because the official language is the English language. And then apart from which, we will conduct all the trial in English. Okay. The accused person will first of all be represented. And then secondly, in certain instances, in my trials, for example, I have had accused persons have interpreters sit behind them so that they will be able to understand what is going on, because they have to understand what is going on for them to be able to properly instruct their lawyers. So at the cost of the service, we have had that. But then the English language, this is not the only instance, like I always say, where we need an actor to be able to understand the English language. If you want to have an independent witness, for example, that independent witness must be able to understand the English language. But this problem is no longer a problem. I'm sure that if we look at the national statistics, we will find that a lot of Ghanaians are able to understand the English language. Not necessarily to be fluent in speech, but to be able to understand what is going on. So language, I don't think, is a barrier now. But then if you do not understand it, it will just take you out of the pool. But then what you would find is that going for if you look at our reforms as we want to go by them now, once we are able to get the staff lists that I'm sure we'll talk about that in detail, and then we look at their job schedules, we'll be able to tell whether language should be a problem for the person or not.
Okay. My lady, so you assemble the jurors. What exactly do they do?
All right. So when they are called, as soon as they are empaneled, the 7 people would have to go and choose a foreman.
Before we even get there, quickly, before I forget, please, what goes into the selection? So do you randomly see people and say that you're fit to be a juror, so come to the court, or I can volunteer to be a juror? I asked this because yesterday, once again on social media, if we can have some of the comments, someone asked whether that is not someone's profession, because their understanding is that is a whole career in law.
Oh, no. People are thinking it's the profession because we have had to use particular jurors for a very long time that we ourselves think they have become professional jurors.
Right.
They go to funerals and they announce themselves that I'm a juror, And
They do?
Yes, some of them do. I have attended some few programs and then somebody will show up, I'm a juror,
But is that allowed? Are they supposed to do that?
They're not supposed to at all. In fact, if I'm doing a case involving anything, I'm not supposed to tell anybody that I am presiding over this case. Unfortunately, people know our names and not our faces, so you just get away with it.
Well, today they are seeing your faces.
Don't forget soon.
They won't.
People are using that to call themselves, and we now don't want to use that system again, that people are so familiar with the court system that they feel comfortable to call themselves jurors. No. Now, the selection, assuming just the list that we are talking about, it is prepared from the district court over the list that we have requested for. As soon as the list is picked and selected. How do you get
the list? Where do they come from?
Yes, we write to institutions. Now we are making court orders and requesting institutions, including private institutions, to provide us with the list of their workforce so that we would look at it and select to see. Even the selection, after we have picked, there is also opportunity for people to come and say for just cause that we cannot serve as jurors. If not, then their names get into the list. It is transmitted to the court, the High Court that is going to have the jury trial. And thereafter, if we are ready to begin the trial, we invite all the jurors in the list or on the list to appear in court. We write their names in certain shades, fold them and put them in a box, and then we draw the names from. So if your name is selected, then the accused person or accused persons, together with their lawyers, are given the opportunity to raise objection to a certain particular juror come in to try their case. And we have two kind of challenges. We have the peremptory challenge, law students will be interested, and then challenge for cause. You know, the peremptory challenge, you are supposed to challenge without giving reason.
Right.
So if, for example, if somebody is involved in rape a case and you see a lady being picked, then the accused person, without giving a reason, might say that this lady is likely to be biased. In his head, we are not supposed to ask anyway. So they will say, no, I object to the trial and then of this person. So we will leave the person out. Go draw till the three opportunities are lost on the person. Thereafter, you have to give a reason. The court will rule on it. So when we get the 7 people, now everybody, the lawyers and the accused person, agree to be in charge of their trial. Then we swear them. We ask them to go and vote for their foreman. The foreman is the spokesperson between the jurors and the court and the lawyers. So if they need anything, clarification or anything from the court, they will speak through the foreman. And the foreman, the court also speaks through the jurors. They are given opportunities during the trial to ask questions if they have some doubts about certain evidence of a person. And so through the foreman, the questions are recorded and answered.
Okay.
And,
so, my lady, Afia Serwaa, these jurors are there to decide whether a person is guilty or not.
That is correct. That is correct.
And many people will ask, what kind of background do they have to make such determination?
They come from diverse backgrounds.
Okay.
But they understand the language and they understand their people. So when they listen, and this is what we always ask them to do, listen to the evidence, take notes if need be, so that you remember what would have happened. Then when they are done, the judge will do the summing up. And in the summing up, the judge will give them directions on what evidence they might have heard, what the law says about the evidence. In all this, the judge may proffer an opinion, but the judge will always be careful to explain to them that, but you are not bound by my decision, by my opinion. What you are, the judge would rather be bound by the verdict. So once they give all the summing up and all the directions are given, the jury will then retire and consider, deliberate on what they would have heard, and then they return with a verdict.
Right.
That is the way they do the work.
Okay, I asked my lady a question, but I think she missed it. That can I voluntarily walk into the court or the registry of the court and say I want to be a juror?
No, you can't volunteer, unfortunately. We would rather have you. Now, for now, at first we're depending heavily on public and civil service institutions. The new way to go now, per the direction of the Chief Justice, is to throw it more, to other institutions. It's now wider. We will invite them to submit their staff list by order of court. It's not an invitation they can decline. And then we will do the registry.
Is it compulsory?
Yes. Once the order is given, they will have to submit. And then the registrar with the Director for Court Services will select the jurors, and it will then be forwarded by the magistrate. Going forward, we will throw it even wider. We are in talks with, we want to approach, actually we've approached them, written to them, got the National Identification Authority.
Yes.
We want to look at Ghana Revenue Authority. We want to look at Electoral Commission, places where we have a certain jurisdictional landscape where you can do the selection. Because the more varied and the larger number we have of a pool, the better it is for the quality of the jurors that we will have.
Right. Do you pay the jurors?
We give them some allowance for
Then it shouldn't be compulsory.
If they come for their TNT and probably for their meal, we give them some allowance for coming, for showing up. And that is what, over the period, if we don't pay, they go on strike. And why the strike thing is that they would not come in the correct numbers that we require them to come. So if 6 show up and 1 is not there, honestly, no work can be done.
Right.
Meanwhile, we would have recorded that they are present. And so if we record, we have to pay them. And that is the reason why we are here. That henceforth, we are not going to do that again. We are going to have one juror panel to sit on one case. And then if you don't show up, if all the numbers don't show up, we don't record you so that we will owe you. And so we pay
But
something.
let me add this, Serwah. First of all, you take a look at the legislation. There's nowhere in the legislation that money is mentioned. Nowhere. There's no LI to this. This legislation does not talk about fees. So it's just reasonable that when people have transported themselves, that is the presumption. But then let's consider it. Hitherto, I don't understand the strike. Because hitherto, these were people who were working at the ministries. So they would have come to work at the ministries. And you cross the road and come to the courthouse at the law court complex. Where is the change in circumstances? But fortunately, we are done with that. Now, going forward also, let's look at it as men and women of the world. I always say this. If you ever attend a meeting, you have a plan to attend a meeting for which you might be paid a sitting allowance, and you get there and there is no quorum, for which reason you can't have the meeting, do you get paid still? No. So why is it that we have a set of 7 jurors? They show up to sit, and one of them is absent for whatever reason, that we still have to pay the 6? Because there was no quorum and there was no meeting. So going forward, we have to be far more judicious with spending judicial money. If we are unable to make progress, we will not do any payment. Even then, the likelihood of having this juror being involved in this case, that case, such that this judge needs him, that judge needs her, no, is no longer going to happen. It is just 7 jurors involved in one case and no other, which would be heard expeditiously. I hope you are going to give us opportunity to explain how the trial will be done.
Yes.
And then we'll finish it in a maximum of 30 days, per the practice direction. In fact, it shouldn't take more than 30 days, and 30 days will be the most complicated. But the regular rape and the rape between the victim, the accused person, the doctor, and who the victim may have told, rest gesture, who she may have told first, that kind of thing, will be 4 or 5 witnesses, won't be many. And we are hearing them day to day, all day. We start in the morning. We probably can call 2-3 witnesses in a day. And then after 2 days or so, if the judge makes a determination that the person has a case to answer, you give them half the day to prepare, because they would have received all their disclosures now. All the disclosures have to be front-loaded. That's the new way. Instead of waiting and sitting for the judge to make orders about disclosures, the new direction is that all the disclosures must be filed before the arraignment. So right from the arraignment, actually on the first day of arraignment, with the disclosure having been done, on the first day of arraignment, PW1 can be called.
Oh, wow.
You understand me?
Yes.
Because there will be no direction now. So on the first day of arraignment, the empaneling is done, case completion is done. Even PW1 can be called, or else the next day it starts. Day to day, all day, 9 o'clock to 12 or 1. You take a lunch break, you come back 2 to 4 until the matter is dealt with. Similar to what happens in all other places in the world. So that is how we are going to do these cases going forward.
Does that mean that if you get a larger pool of jurors or persons to choose from, you're going to move away from the selected crimes that we have the jury trials to open it up? Because in other jurisdictions, even in civil cases, you have a jury trial.
No, we will still maintain our law as it is until there's law reform.
Right.
You see, we are still working with the 1960 Act, but until there is law reform, we are for that one. I wouldn't. I would personally maintain the classes of offences that are tried by jury, but I am all for expanding the jury lists and introducing other things for law reform. My personal view of law reform should be dealing with technology routinely. For me, I think we should, for instance, deal with electronic evidence routinely, because policing and law enforcement has become technological. So everything should be electronically dealt with and possible. We don't have to ask the Chief Justice for a warrant if a witness lives abroad or is in some other country and wants to testify via video link. I think issues like taking evidence on commission and preservation of evidence should now be such that you record it electronically for the person for it to be played. You know, I think we should introduce more technology. We should also, I think, introduce soft copies of things. We should have voice to text, so that we can have people, you know, so that we can have the trials going faster.
But is people raise the concern that in this day of technology, it can be tampered with? People are able to edit voices and insert things that were never said. Does that not bother you?
Oh, there are ways of dealing with this cyber security wise. Personally, and I digress a bit, but personally, I have tried a case where the witness was testifying via video link, and it was obvious that the witness was being interfered with, because you see, it is natural for somebody's eyes to be moving and so on. And then there are other ways that you make sure the person is sitting in a room. From time to time, you let them, you know, circulate the device to check, because if we should circulate your device right now, we'll be able to tell who is in the room and who is not. That is how we deal with it. But for me, for law reform, these are the reform the CJ is doing now. It's not something that needed legislation to be carried out.
Okay.
But I think also that we should, for instance, instead of relying on NIA's goodwill, we should have a legislation which says that the Identification Authority should submit their citizens list every quarter, every 6 months, every year, from whom we can select. We don't have to ask them for them to decide whether they want to give it to us or not. We don't have, so if we are able to make the legislation firmer, I think will put us on firmer ground. But even then, with what we have now, I think that a lot of thought has gone into it, and it's obvious that things are changing.
Okay. My lady Osei, so once again, based on on what people have been saying to the juror system, have you ever had jurors come back with their deliberations or their decision, that as a lawyer, applying the law, looking at it from that angle, you say that, no, maybe they could have reached a better decision, but you don't have a choice that to take it?
Yes, I have. Last year, I had a case that for me, the best evidence ever had been churned out during the proceedings. There was confession statement, there was video evidence of the confession of the accused person. There were a lot of enough evidence that they were directed on to have been able to return a verdict, at least either guilty for murder or guilty for manslaughter. And yet they came back and said the guy was not guilty. They had even a hung jury. If they had said not guilty, I would have been satisfied, because then the process would have gone on appeal for somebody to check if the judge directed them adequately. But they didn't, and then they will return. And the law doesn't allow a judge to interfere with their decision. So however the decision was arrived at, you could see emotions were played, and yet they will come back and tell you. The best thing you can do, if they bring a verdict, which is not to you, if you feel they didn't consider the evidence well or the law that had been directed, you could ask them to go back and deliberate further by drawing, probably, if you have challenge with this, please come back for clarification and all that.
But at what point are you able to do that, when they have already returned with the verdict and the entire courtroom knows that they have a verdict?
No, when they bring a verdict, which is not the unanimous or the majority, and you want to direct them further, you can ask them, go, because in your mind, you think you directed them on this. There was this evidence. The law says on this. You have to have looked at this. So you just go back, deliberate again. If they don't have a verdict, you would actually ask them to go back and deliberate. If they have a verdict which is hanged, probably you can ask them to go back and deliberate and tell the court if they have reached an agreement. The agreement doesn't mean that at all costs they have to bring a verdict of guilty or not guilty. It should be one way. If it is guilty, they have a verdict. If it is not guilty, they have a verdict. If it is hanged, they have not had a verdict. That's you can ask them to go back and deliberate further. Probably if they deliberate further, they can come back and either return a verdict of not guilty or guilty. In that case, we will not have the burden of doing the retrial of the case again. The reason why we would want to ask them to go and deliberate further is to avoid the instance where we will have to do the retrial if there's a hung jury. But if not, and they bring a verdict which is guilty, you are bound. If it is not guilty, you are bound. You record it. If it is guilty, you give sentence. If it is not guilty, then you discharge the accused person. Whoever doesn't agree with it has the right to go on appeal to look at the directions that the judge gives.
Okay. My lady, there are allegations of jury bribery. I don't know how true it is, but how do you check that these, because if jurors are going around announcing that they are jurors, people will definitely know them and they may approach them, because the allegations that some absent themselves because lawyers tell them not to come, so that it delays the process and delays everything. Have you gotten
I've never heard of anything you are telling me. I have no idea that jurors get corrupted. I just wonder that they get confused sometimes. But if they, because sometimes their decisions may not make legal sense. I personally believe in the good in everyone. I find it difficult to imagine that people actually would be able to collect bribes and corrupt justice. However, is it that sometimes people have other considerations than the law they have been directed on, or the facts? I have seen that sometimes they do that. For example, I always give this example. You know, I was a state attorney before I became a judge.
Okay.
So I have seen a lot of things from the prosecutor's point of view and then from the judge's point of view. I have never done criminal defense, so I don't know how criminal defense works. But I do understand that the lawyers will do what they can to help their clients. But I have seen that in certain instances, if for instance, in all my experience, I've seen that whenever there is a homicide in a family relationship, you know, somebody kills his mom, someone kills his brother, the jurors find it a little more difficult because these are brothers and the mother is the witness. How do you call a mother to testify against her son? And especially if there are only two and one is dead by the hand of the brother, you know, that kind of thing. I think then there are also those who may have certain religious views, but which they are not letting on. If, for instance, there are those who feel, in those days that we used to have a lot of mandatory death sentences, there are those who say that you cannot kill another person. So as they sit there, if a guilty verdict would mean that they would
be sentenced
would be sentenced to death, then no matter what evidence you lead, they are not ready to hand down that for you to get the judge pronounce a death sentence. So that is why we also do the kind of orientation which lets them understand that if they have those kinds of views, then they should let the court know. But even then, now that we have moved away from a lot of the death sentences, we can see that then there would be a change. I mean, we've moved away from there. No death sentences now, just life. And even for the treason and high treason, since 1992, we've not had any president sign a death warrant. So I think now they are more settled in their spirit. So in the directions and in the addresses of the lawyers, they are supposed to explain these things to the jurors. We are supposed to be neutral arbiters. We listen to them, and then we also hand down our directions. As for bribed jurors, maybe people will suspect. I have no evidence at present.
We can't have the evidence because whoever is
But
going
have you
to
heard?
bribe, yes, sometimes
You have heard?
You hear this because one time long ago, a juror told me, in this case, people were after us, but we
stood our ground.
We stood our grounds, you know, so it's a possibility. I will not rule it out, especially when, in my opinion, the evidence was that strong. So other than emotions or something else which I can't explain, then something may have gone wrong for them to have returned a verdict which cannot be explained. In any case, you know, I tell them that you are the conscience of the society where you are coming from. The society expects you to speak their mind. So any other thing you say which does not sit well with the society, you are ridiculing yourself. You are offering your services as a citizen to a society, and therefore it is expected that the people on whose behalf you are in the courtroom to sit on a case as a judge should do the right thing and judge impartially. I have a number of biblical quotations that you can say that I would, whether I use it to coerce you or to, I just want you to have in your mind that you are a judge on earth, but there's a greater judge who expects you to be impartial. So I'll quote all that to tell you that if the person is guilty, her father says, pronounce the person guilty. If not, pronounce the person acquitted. And I'll tell you that, and leave the rest to your conscience. If your conscience tells you that some monetary consideration is better than doing the right thing, it's up to you. At the end of the day, when you go to your bed, your conscience is your best judge.
Okay, but I want to understand, how do you protect the jurors? Do you camp them somewhere, or they finish from the courtroom and they go home?
There is a room, every courtroom, at least in Accra here, we have, and in other regions, one region I'm familiar with, there's a jury room, so that is where they are supposed to be. But the challenge is that when the case goes on an end,
Sorry, my lady, let me understand.
Familiar.
You keep them before the start of the trial for the day,
yes,
but not to camp them as
no,
in sleeping there.
No, we don't have now. We don't have the resources to keep them.
In other jurisdictions, are they camped?
They are sequestered.
They are.
Okay.
They are sequestered. But now, with the new practice direction and administrative of the Chief Justice, she has indicated that where the judge is of the view that there would be the necessity to keep the jurors in residence, the judge should write for funds to be made available for that purpose. And so we shall see if the cases are particularly sensitive and there's a need for speed, seeing as we are looking to finish cases in 5 days, 10 days. Now remember also that the Chief Justice also has the authority to issue warrants for the courts to sit on weekends, holidays, anything. So now I think this legal year, let's put it to the test. Yes. Let's put it to the test.
At the end of the day, people would have to know that this is the role I have to play and play it well. Because even if we camp them, people are in possession of their phones. And anything happens on their phones, you don't know. You can't control that, you know. So the crux of the matter is that let's have people who have good conscience, who are men and women of integrity, and who will do it as it should be, so that whether or not there are cameras, they will do the right thing. That is what we are trying to say.
Okay. Well, this legal year, we'll be looking forward to all these reforms that you have in place. But speaking of reforms, you know, I know that this may be a little out of line, but like I told my viewers earlier, it's the only time you get judges to respond to anything or even speak at all. You never do. And I have been admiring her especially for a very long time. So I want to ask you this. I'm sure that you have seen the many reports, the surveys that have been done on the judiciary and how people perceive the judiciary to be corrupt and how they do not have confidence in the justice system. What is your response to those people who believe that even when they have a case, looking at how they perceive the judiciary to be corrupt, one, how long it takes for matters to be tried, and how they are not confident in what verdicts will be given by the court, they sometimes just may give it to God or take matters into their own hands.
Now let me ask, these surveys that they do they actually do surveys on people who actually have cases in court? Or they just do surveys which are, what's the word?
Skewed.
Not just skewed. I'm just thinking of something which is like a set of facts which may or may not exist. Now, the reason why I'm asking this is personally, I have not been a judge for very long. I'm only in my 11th or 12th year. But personally, I have done over 400 judgments, 400, 500 judgments, personally. I have, in cases, when it was civil cases, for example, done cases where from start to finish, from filing to judgment, it took 4 months. From filing to judgment. Now, these cases that we are talking about, doing cases from day to day, all day, and the fact that we are doing case management such that we will do the cases with a case completion plan and so on, I have been applying it since 2020. So it is not new. Unfortunately, I will not at all deny that there are some people who do not go by the strict practice directions that the Chief Justices give. If a Chief Justice hands down a practice direction that you are supposed to do a timetable of your cases, I think that they should comply, and some of them don't. But then, if anybody, you have been going to court, I am certain.
Yes.
You know that even among the lawyers, they know where they can play and where they can't. You know it. So we have a difficult job. The job of just sitting and doing cases and not being able to say anything. The difficulty is the fact that when people lambast us in the press, we don't have the opportunity or the right of reply, but we get the jobs done. I wish also that you would also go on the system and, of course, check what the numbers look like. We are inundated with cases. But I know that every year, so many cases are disposed of. Now, the same press, this same public, when they have a judge who actually hears the cases from day to day, all day, that judge also has a problem. You must be interested. Why are you in a hurry to finish cases? It is only in Ghana that a judge gets poor press and poor comment for doing their cases quickly. How can that even be a thing for anybody to complain about? That you have done your cases and you've done them quickly. I once had someone who petitioned the Chief Justice against one of my colleagues that he was certain that the judge was interested in his case because the judge was insisting, one, on adopting the proceedings. It was a matrimonial matter. In adopting the proceedings from the previous court, and two, in hearing the case from day to day. And so when that petition was lodged, the justice decided that she was no longer interested in the case, and she asked the Chief Justice to recuse herself because the petitioner or respondent, I don't recall which, had complained that because she was doing the case quickly. So then the Chief Justice transferred the case to me. I heard it from day to day, all day, for 2 weeks until the matter was dealt with. And I said, because that is the right way of doing cases, doing the cases from day to day, all day. Judicial corruption, unfortunately, because of some happenstances previously, people can talk about judicial corruption. But then that same happenstance indicated that there were judges who were not corrupt. They indicated there were people who were not corrupt. Who gives these judges the money? Where do they do it? I wonder. How do they get the gumption, as my grandmother used to say, to go to a judge and dare to offer them anything? How do they do it? But then when they go, they turn around and I don't know. But personally, I think, yes, our judiciary can be better. We can do things a lot better. But now that we are doing better, I don't expect people to say, oh, it's going to fail. I expect them to give us the benefit of the doubt and observe what we are doing. I think that we are not only dealing with jurors, we are dealing with every stakeholder. If you look at the administrative direction, Every stakeholder is involved, even the judges. We are supposed to be reporting, and this reporting started last year. I am the one who compiles the completion plans. So going forward, and I report to the Chief Justice almost every week on how we are dealing with these cases and where we are going. So please, Ghanaians, first, have patience for us. Second, wait and see. And please pray for us. We'll do great. I promise you.
My lady, what do you have to add to that before we move away from it?
So what we are asking is that this reform work best if we all cooperate.
Not that one. Not that one. On the perception of the judiciary.
Yes. Sometimes you see people are vicious. So in their mind, they think people can do things funny. So they would start throwing their stone where actually there's actually no reason to do that. Sometimes they think it must go their way, and if it doesn't go their way, one thing we have to bear in mind is that whatever happened between the parties, the judge was not there. We only work with the evidence. So if we get the right evidence, exactly so we are going to pronounce. And if you think you want to see a judge, so report yourself that me, myself, I have gone to see Judge A to work in my favor. So don't throw it out there as if one person is the evil. Whoever is going to give the bribe is as guilty as the one whom we claim has collected it. So in my opinion, personally, like my senior said, it is those to whom they look at your face that they can say that to, not to some of us. Because throughout my practice on the bench, if you joke, I'll mention your name in open court. In my lower court days, if you go to see the registrar, that I will go and see the judge in respect of this case for me. As soon as I sit, I'll call that case first, and I tell you the parties who are going behind me to seeing these people. So nobody messes up with me. I'll just blow the cover on you. And if you do that, you are at peace. Nobody can try you. And I'll tell you, in this case, please, I am not able to tell my sister to go this way or that way because I'm not in the know of the evidence that has been produced there. So if we all play our roles very well, this perception would go. But I just want to say, generally, a good number of the perception people carry out there are wrong. It is because they would want to come out to say that we think the judge is biased because he has taken bribe to make them look good. Their cases are often bad. Otherwise, why would they want to go and see somebody to help them? So generally, it's not everybody that is corrupt. It's not everybody. And unfortunately for us, we are not able to answer for ourselves. They throw it out there so painfully, and then we can only listen and then do. But one thing is that if we bastardize the court often in the media, and people lose confidence in the media, that is the only platform that you go neutrally to vent your problems. So if we are saying that, oh, they are all corrupt, then, you know, as soon as there is something, people want to take the law into their own hands and do the wrong thing. It's not like that. You are becoming a lawyer very soon, and you appreciate where we are coming from. It's not always the case that the court system is as bad as people are painting it. I can assure you, my dear.
But you've been doing your court work.
Yes, my lady.
When you go there, you actually see people actually working. And I'm sure you are working with lawyers. Does it look like the lawyers have such no confidence such that they don't want to study, they don't prepare for court? No.
No, not at all.
Exactly. So if the lawyers thought that the system was so bad, they wouldn't spend hours just drafting their documents and so on. So it's easy for people to say, because a lot of people speak from a point of ignorance. Personally, I have done cases where we have a group of 10, and I've acquitted 2, 1, because that is what the evidence is. Years ago, I sat in respect of the case of the current majority leader. I acquitted him after a few months of a hearing because the evidence was weak. Why did anybody not say at that time that he was then in the minority, that there was something wrong? Is it because it goes a certain way? No, it shouldn't be so. So I think you know what goes into this. We don't sleep. So it is just wrong for everybody to just put everybody in a certain bowl. And I wish people would also name names. I saw so do this.
Exactly.
Then we'll be on firmer ground. They should tell us where they saw people and what they gave to them.
Okay. My ladies, before we go, let's, wrap up on the reforms on the jury. So if there's someone who is watching, I said that I wanted you to respond to a few comments on social media. If my producer can just give me 3 minutes to do that, if we can. So Arthur Serwah says, why would they allow ordinary people carry the burden of someone's death? Why are we paying judges?
It has nothing to do with whether we are remiss in our responsibilities at all. It is what the law says. And it is what happens in many places in the world.
Okay.
Like you rightly pointed out, in the US, for example, it is done in both civil, in all cases, at the trial level, jurors are involved. That is what the Constitution requires, that for such serious offenses, there should be a jury to try them. We love our job. We don't want others to take over.
My lady Osei, for this one, someone says, well, no, I don't want to be a jury because the smallest mistake could mean ending someone's life or let a criminal go scot-free. I just can't stand the guilt. How do you, work on the mindset of people like this?
My senior said from the beginning that we train the people who come to serve as jurors. We tell them this is a civic responsibility required of you by the Constitution of our country. It is not about being guilty about. If you sit in proceedings and listen to what people do, and at the end of the day, what victims have gone through, and you are supposed to agree that, of course, this offense was done by this person, you should not have any guilt at all. You would have done justice to the situation. I always tell my jurors that the matter is not close to you. So now you don't feel the fire. If it is close to your relative, then you will see how important it is that your verdict is so important. Nobody should feel guilty that I'm going to, for my sake, somebody is going to prison. Have you thought about that young lady who was killed in cold blood by that person and who needs to be punished for it? Have you thought about the family of that person? If the person were to be your niece or your daughter, would you have asked, oh, let the person go?
Right. Okay. So there's also another one, but I think my lady has already answered it, gone through the tall list of persons who are ordinary, who can be jurors. So let's see the next one, please. So the jury, to some extent, use common sense rather than strictly adhering to the law. Is that the case, my lady?
Not necessarily, not quite accurate. They will be given directions on law, and then they will determine the facts.
Okay. Can we have the next one? I think this one, so it says, okay, someone is willing to try it. It's an experience that will be worth my while and an opportunity to widen my horizon. But you say you can't voluntarily walk in and say...
But I would encourage people to be quick to accept jury duty. When I was a state attorney years ago in Kufuridua, 96 thereabouts, when we finished the session, we had a formal opening of session and formal closing, similar to what we are now introducing.
Right.
When we were done, we had the jurors comment on what they had experienced. All of them said they had learned lessons for life. People don't realize how fragile human life is, how easy it is to become a murderer. It doesn't take much to kill another person. How anger can cause problems for people. So by the time people are done, the jurors are done with their duty cycle, they would have learned many lessons. And I think even with law students who haven't even finished, by the time they are done with their studies, they just come to the realization that there's a lot more to life than what we see about just maybe dressing the part or sitting the part. No, there's a lot more to it than that.
All right, thank you so much, my lady. Her Ladyship Justice Afia Serwaa Botwe, who is a Justice of the Court of Appeal, and her Ladyship Justice Lydia Marfo, who is also a Justice of the Court of Appeal. Thank you so much for the honor of having me host you this morning. I'm very grateful, and I'll cherish it forever. Thank you for watching the show on behalf of the entire team. And thanks, special shout outs to the Communications Department of the Judicial Service as well for making this possible. Thank you for watching. I'll see you same time tomorrow, God willing. Have a good morning.